Are we good? Okay. Okay. So I wanted to give a talk or an update on a project that's a global project sponsored by the United Nations, but it's also quite a lot of uptake around the globe for business and human rights. You may or may not be aware that historically around 1980s or 1990s, actually, there were several cases of companies being involved in human rights abuses, and especially in extractive industries, et cetera. So oil and gas companies, Bhopal, lots of different situations where companies were involved in actually violating human rights and causing significant issues among particular people in society, to the point of actually also committing international criminal violations. So, for example, in Nigeria, the oil and gas companies would hire local militia to murder, rape, kidnap protesters who were fighting against pipelines and drilling, et cetera. So these cases were trying to find a home because they were not able, well, finding a forum, finding a place where people, the victims, could go to press their case and get justice was very difficult, because a lot of times the companies were from different jurisdictions than where the violations took place. And a lot of times they involved different players, they would involve state actors, et cetera. So it was very difficult to find a place for these cases to be brought. In addition, there was this strange anomaly that came along whereby if we think back to World War II and the post-World War II period, when international crimes were sort of developed as a process, then in that context, when the Nuremberg trials happened and the Tokyo trials happened, there was a proposal that companies that were involved in these activities should be held liable, because companies, contrary to what you might think or not think, companies are actually persons under law. They're not human beings, obviously, but the law recognizes them as a separate juridical being. And so there were cases, at the time, there was proposal to bring the companies to justice. And these proposals were rejected at that time, and international law in this context specifically focused only on individual behavior. So only individuals could commit international crimes, war crimes, crimes against humanity, et cetera. Companies could not. And so in the 80s and 90s, when companies were committing all kinds of acts and crimes and violating human rights and participating in trafficking and slavery and et cetera, there was a bit of an uproar, because people said, well, Pirates Incorporated doesn't make sense, right? If you're a pirate as an individual, you can be held accountable for international criminal behavior or human rights violations. But if you incorporate yourselves as a company, well, then you're all scot-free and there's no liability. And so people said this is very problematic. And there was a very famous case in the US called Sosa, and then it was also followed by Kiobel. And Kiobel was Royal Dutch Shell being persecuted in New York courts, New York or US federal courts, for violations in Nigeria against Nigerian individuals. So all the activity happened outside the US. The company was outside the US. The individuals are outside the US, but the case is brought in federal court in the US. And so people got a little bit agitated by this in the community, in the business community, and obviously put pressure on states to say this is completely inappropriate forum and a completely inappropriate place to bring this kind of action. So this case highlighted these two particular problems. The first one being that companies can't be held liable for human rights violations, which is a gaping hole in the Human Rights Project. And then the second one was there are no fora. There's nowhere to bring a claim, because there's no way for anyone to bring these claims, because if the government of Nigeria and the army there are being hired by Royal Dutch Shell to perpetuate these kind of crimes against Nigerians, the state of Nigeria isn't going to allow these victims to go into federal or to courts in Nigeria, right? The state's going to prevent that. So there's no forum for resolution of this problem. So because of these particular problems being identified by the international community, there was a proposal put forward by the United Nations that this area be studied for potential remedy, for potential regulatory framework, et cetera. So originally there was the Ruggie Report, and John Ruggie was appointed special rapporteur by the United Nations to come to investigate this area and gather a whole bunch of information and prepare a special report. And so he was supposed to figure out what's the state of play, what are the potential remedies, what kind of regulatory framework might we come up with internationally to involve states and international institutions and utilize the tools at both the cosmopolitan and metropolitan level, treaties, local legislation, local forums, human rights tribunals, et cetera. How can we put all this system together and make it function to give some sort of remedy to the victims of human rights violations and international criminal law violations? And so his report, which was issued in 2011, proposed sort of 3 pillars upon which to found a regulatory framework for this space internationally. And the first one was that states have a duty to protect against human rights violations. So we need to leverage the state's power in this space to try to get them to be the base of how the system will be regulated, because they're the ones who have a duty under international law to protect human rights violations. And then what he said was, well, we need to obviously involve corporate actors, because corporate actors are the whole, is the problem. So, but you can't mandate at the international level that companies do things specifically, because companies are domestic law creatures, right? Created by the nation state in which they're registered, et cetera. So you can't have international tribunals have an impact, they don't have jurisdiction over companies. So what they said was, we'll impose, or we'll recognize that companies have a duty to respect human rights, which again might sound problematic and a bit mushy, because what does it mean to respect human rights? You know, okay, we don't torture. You know what I mean? That's not helpful. So there's an enforcement mechanism problem here, which is trying to be addressed, but it's going to take time to get there. And then the third pillar was, how do we develop remedial systems, right? How do we leverage national systems of jurisprudence and law and courts and non-juridical responses? So civil society, other tribunals and institutions, and how do we put together an entire framework involving all the stakeholders at all different levels to leverage pressure enough on the business community to actually improve on human rights commitments and prevent human rights violations, et cetera. So it's a big report, and it's actually quite influential. It came out in 2011, which is why I named this Business and Human Rights at 10, because this next year, this project will turn 10 years old. And the United Nations has recognized that we've been through 10 years of initial development. Now they have a new formal program called the UN Guiding Principles plus 10. And so that project will actually assess where we are now, what's happened in the last 10 years. And then next year, they'll have a big forum, a big meeting where they will take all kinds of proposals from anybody who wants to contribute. So if you're interested in this space and you have any idea how they might do any of this, let me know. I can send you the information. You're allowed to contribute. They're taking comments from all around the world, from all kinds of different stakeholders on ways to advance the project further for the next 10 years. So 10 years is sort of a good cutoff point to think about how to transition. What are we going to do for the next 10 years from the United Nations perspective? Okay. So I'm going to focus mainly on 3 proposals that have been put out and have been developing over the last 10 years, and talk about the effectiveness of them or the necessity of them, and also talk about different I'll give you sort of over the last 3 weeks, there's been a lot of movement in this space. Again, I think because of the recognition of 10 years. So I'll sort of give you a quick update what's happened even over the last 3 weeks as to these 3 particular points. So the first one is a legally binding treaty. And so there was a recognition back even in the Kiobel case that around 2010, 2011, people started saying we need to have a formal treaty. And Ruggie was against this. He said that he can't figure out any way you would structure a treaty that would work in this context. And so he was completely against the treaty. But there's a whole group of people who are pushing for this treaty. And there's a working group established by the United Nations that are working on drafting a treaty, which they did. And we're now up to the 3rd draft. So you can't really see it here, but this is the PDF of the 3rd draft. So I think we'll be able to make this available to people. So if you can actually go in and look at the PDF. The PDF is actually attached in here. So if you click through, you can read if you're interested. Okay. So the draft treaty is similar in nature to what you might be familiar with from anti-corruption treaties, right? So anti-corruption treaty has a particular methodology that it adopts where it tells the states that the states must pass legislation to prevent corruption. And so this is a similar type of proposal in this space. So what they're doing is they're saying that companies are considered persons, companies have responsibilities under human rights law, and the states are now going to be obligated through the treaty process to implement domestic legislation which holds companies accountable for human rights violations in different contexts. And that will be subject to peer review by other countries, just like the anti-corruption. So they're modeling on anti-corruption and anti-bribery treaty, UN one and OECD, to try to implement a similar type of regulatory structure in this space. It's gone through a 0 draft, 1st draft, and now it's on the 2nd draft. And we could go into detail on it, but mainly what's interesting about this is there's a recognition, and that recognition is becoming more pertinent, that you need to have this treaty in the background as hard law to force the states, to force the companies to act in certain ways. Otherwise, it's just not going to happen, right? Yeah.
There must be also some resistance.
Yes, yeah. Yeah. I mean, a treaty in this context is quite difficult, obviously, because first of all, you're going to have the corporate actors lobbying very hard to not have this implemented. So there's a huge corporate lobby pushing back against this entire treaty process, because once it's legally binding, and that puts the states against the corporate actors, whereas right now the states are aligned with the corporate actors, right? So once you have the treaty in place, now the states have the binding obligation, and that's going to set their interests against the corporate and force the corporate issue. And obviously, corporations don't want that to happen. They want to have the governments on their side. Yeah.
So it's a question of a strong political will.
Yeah, I think there are other stakeholders at play, right? So you've got the entire human rights project as a global project, civil society, the human rights bar, which is the lawyers, right? Everybody in that context and trying to protect human rights, and all the human rights organizations and everybody on one side, and leveraging their power with the United Nations and through the United Nations to help push on as a resistance to the corporate resistance side. So you have these competing stakeholders, and again, the states are trying to figure out which way to go, and they would again rather have a globally binding treaty where everybody has to jump all at one time holding hands, so that way they don't have any particular problems for competitive issues, or if we join this treaty but they don't join this treaty, businesses will migrate from our jurisdiction to another jurisdiction where the treaty isn't binding, so they want to be able to have everybody jump all at one time. So there's collective resistance, pushback against the business community. Yeah.
I ask, because When you place states versus immigration, what about states that suffer from state capture? What about states that are dominated by corporations?
Well, but this is I think what I'm trying to point out, that right now most states are captured by the business community, and they're resistant to actually having this whole project go at all. But by having a treaty at the United Nations level, they can always say, well, our hands are tied now. We as states have an obligation, a legally binding international obligation to push forward on this. So unfortunately, companies, as much as you want to resist, we have an obligation to pass legislation, and we've got to pass the legislation. So otherwise we'll have an international problem under the treaty. So again, it gives them a backstop and gives them some excuse to push. Whereas right now they don't have any excuse to push, right? So they're completely captured. So this sort of breaks that link. Not completely, but it's helpful. It's worked very well in anti-corruption space, right? I mean, corruption is the best form of state capture, right? It's the quintessential state capture. And there was an international treaty against corruption, an anti-bribery treaty, and now all the governments around the world, surprisingly enough, even here in Southeast Asia, most states are now adopting anti-bribery legislation. The reason they're adopting that legislation is because a treaty obligation requires them to adopt this legislation. And so they're all adopting. Even Thailand has very similar anti-corruption, anti-bribery law to the UK's Anti-Bribery Act. So and we'll talk later about how the success of the anti-corruption project is now seen as a means for doing the human rights project, and they're linking them together to ride on the infrastructure that's been created. So we'll talk about that sort of at the end, but that's a new development that came last year. Sorry, she had a question first, yeah.
I just want to know how countries would agree to sign this new treaty, because states, I mean, just as much as businesses need these states, and I think the states need these businesses, as corrupt as they might be, or as whatever, they need them. So I don't think anyone really.
Yeah, but I think again, this is the whole point of the UN, right? To give them a collective action forum for the states to push back. And again, the same arguments were made for anti-bribery and anti-corruption treaty, right? Everybody said, well, nobody will ever pass it because the governments all get their money from corrupt, companies who are paying lots of money to them all the time, and this is how they live their lives. And so, but actually it was passed, and actually it was passed at the OECD level, and it was also being implemented now through domestic legislation according to their state's obligations at that level. So this mechanism for sort of decoupling the state from the business community and pinning them against them and giving them an excuse for having to do it has become an effective way to leverage back on that. And it worked very well in the anti-corruption space, right? So anti-corruption is a really big success story in utilizing this kind of regulatory pushback structure through the international system. Yeah.
Just ask, are these treaties and legislation are applied in the realms of international law, or do we have participation?
Once the treaty is signed, it's got the force of international law. It is international law by definition at that point, right? There's not necessarily an enforcement mechanism, because obviously no one state has power over other states. But at the international level, all international law is that way. It's all consensus. But they have peer review process, and this is what's successful about the anti-corruption, anti-bribery, and it's also successful in other types of modern treaty working. States give other states the power to come in and review their legislation and enforcement, et cetera, and they write up reports and present the reports globally, and it's a naming and shaming kind of thing. And they also make blacklists. This guy's legislation is not good enough. Don't do business here. Don't act here, right? And so by naming and shaming and blacklisting people, and this is really successful in the anti-money laundering space, right? And in the tax evasion space, this sort of whole naming, shaming, blacklisting process has been very effective in pushing that forward, okay? So beyond the treaty aspect, which I just real quick on the treaty, the working group who's dealing with the draft legislation met fairly recently, I think last week, and they made very little progress on changing or adapting or improving the language. So that we're at a bit of a standstill on that front. Part of that may also be the recent pushback globally on international systems, which has been facilitated by the current administration in the US, abandoning the space and other players internationally taking advantage of the vacuum of power to put a lot of these international projects on hold, right? So whether that will change when the new administration comes in, and hopefully things will go back to a more normal type of international process, but we'll see about that, okay? The second thing I want to talk about are mandatory disclosure rules. So there is a proposal under the process, and it's part of the Ruggie Report, and it's specifically listed in the Pillar 2 about corporations having a duty to respect human rights. And as part of that, his recommendation was that states should mandate that companies perform due diligence throughout their supply chains and check to see if there are human rights violations being participated in by anybody in their supply chain. So there's a due diligence process that's supposed to be adopted, and the states are supposed to push forward on that due diligence process. So this is an example of the state now going against and putting legislation in to try to force companies to do something, as I mentioned before. So mandatory disclosure, Europe is the furthest along, and they have actually proposed legislation that will require companies to perform mandatory due diligence on their suppliers and through their supply chains to see where there are potential risks for human rights violations. And they're not supposed to actually stop it, because they might not be able to stop it, but they have to include in their annual reports that they prepare, their annual general report, their annual audit report that they prepare for everybody. They will have to include now a section that shows how they are performing due diligence and what they're actually doing in the supply chain and the results of their work, et cetera, and disclose that to the general public. And so it's a disclosure type of regulatory tool where sunlight is the best disinfectant, as they say, right? So if you can make companies perform this and they have to report on what they've done, it incentivizes them to actually really do something, as opposed to saying you have to do this or we're going to punish you. It also gives civil society ammunition to use this information to push back on those companies that aren't performing due diligence or are committing human rights violations in certain industries. So like fisheries industry or garment industry, et cetera, where there are abuses. If this information if the due diligence is performed, and this information is presented in annual reports that the civil society can look at, then civil society can say, this company is not meeting its obligations to respect human rights. It's not performing proper due diligence. We're going to name and shame them. So it allows not just state actors, but allows the civil society to pick up that ball, and they have the information to do it. Right now, they don't have the information to do it. And so this promotes that. There are some issues around this. There is a problem called information paralysis. There is too much disclosure these days on lots of different levels, right? If you pick up an annual general report of a company, sometimes they're 400, 500 pages thick. And the information in there is just so voluminous that, no one can use it, right? There's a point at which companies like more disclosure because they might have to pay a little more to disclose stuff, but they know nobody's going to read it. There's too much of it. So as a tool, it's a good mechanism in theory. In practice, it can be a little bit of a challenge as far as the implementation process goes, right? But there's hope that will actually happen. So again, the EU has mandatory disclosure due diligence legislation proposed. The uptake is progressing, but it's very slow. Obviously, the U.S. is not interested in this at this moment under this administration. There are a lot of other places who are not interested in this at this moment. I will note an update again here. If you were listening to the news last Saturday, you may have heard 15-second blurb, maybe once or twice during the weekend, that Switzerland has rejected mandatory due diligence in a referendum. So there was a referendum on mandatory due diligence legislation and human rights violations for companies put into the Swiss system. And the Swiss people rejected this legislation. But I don't think they rejected this legislation because of it. There was a tandem argument of some sort. I think it had something to do with gun rights or something that was attached to this legislation. And their voting down the referendum was mainly because of the gun rights thing and not this legislation. So it was a very tricky way for the politicians to be able to get this defeated through glomming something else on. So there was enough interest in this that there was a significant uptake. So they think this is not actually dead in Switzerland. They're going to try to decouple it and try to go at it again in a different context. Okay. So the last one I'm going to touch on is, as I mentioned a little bit ago, there's now a working group that was established last year in Geneva. They met for the first time in October of last year. And there was a realization at that time that the anti-corruption, anti-bribery program has been such a success, and there's been so much uptake, and there's so much movement on it. I mean, we hear about it all the time, right? You can't go a week without hearing lots about anti-corruption legislation, or FIFA, or someone else, and everybody's getting caught in anti-corruption violations, etc. So that has been such a success. And given the synergy, for lack of a better term, between human rights violations and corruption, there was a movement to sort of join them together and see how they can piggyback the human rights agenda onto the anti-corruption agenda, because the program is much more advanced, obviously. And so the anti-corruption agenda has the treaty to back it up. So this gives support for the human rights treaty to be developed further. The mechanism by which anti-corruption has been adopted, and especially with the UK Bribery Act, is very unique. In this context, what the UK did was they took on directly the corporate liability issue, okay? So historically, when it came to bribery, an individual who paid a bribe or offered a bribe was violating the law. What the UK did was they said, if you're a company and anyone you're associated with pays a bribe, offers a bribe, whatever, the company itself will be liable for a criminal violation of anti-bribery law. So the individual people who are agents or associated with that company, the company will now be automatically liable, right? The only defense they have is if they've put in an anti-bribery system within their organization. So if they put in policies, procedures, etc., due diligence, all of this inside, then that will give them a defense against their criminal liability, which is a very unique approach. And now human rights is saying this is probably the approach we want to take. So we'll have the treaty in the background, which will obligate the states to implement this same kind of legislation and expand on anti-corruption and include human rights violations. So this is where we're sort of heading in that context. And so that's what I think will eventually happen. But I think as this next year comes around, when they reassess where they're going, et cetera, I think that's where they'll end up. Okay. I know that we're quite far behind on our time, so I don't want to keep anybody too much longer. But if you're interested in this, let me know. I have a lot of material on this, or if you want to contribute to anything, or want to contribute any comments to the UN or anything like that on what you think might be a good idea, then let me know. I can give you the links and all of that stuff. Okay. Okay. Oh, thank you, Bob. Any
questions?
I know you guys are your schedule's quite stressed. You're okay?
Maybe we have time for one more.
Okay,
question,
okay.
Because we can put panel discussion.
Okay,
in
right.
So
Okay.
maybe 1, 2 questions maximum.
Yep.
We're talking about
Yeah.
system in the company, transparency,
Yeah.
all of this.
Yeah.
Do you think that within the treaty, certain template for it?
I'm sorry.
A template, a certain structure should be.
Yeah, so this is actually they wanted to avoid this, and the reason you want to avoid this is because if you think about who you're trying to get to move in the space, you're trying to cover all businesses, right? Not just large multinational companies, but all businesses everywhere. And so if you're a very small business, the risk of corruption may be quite small. So the process and procedures you need in place to prevent the corruption from your own employees may be a very limited type of procedural mix, right? Whereas if you're a larger company, and depending on what industry you're in, the risk of corruption may be greater or smaller. So they wanted to provide companies with the flexibility to make risk determinations and risk assessments as to their own risk profile around corruption and set in appropriate procedures that work within their space for that. And so the treaties don't address that. The treaties say that the states have an obligation to pass legislation. And this is the model legislation that the UK has come up with that everybody's adopting around the world because it seems to be the best model for hard law regulation of businesses. So again, they're taking a risk assessment approach because it would be impossible for, let's say, Thailand's government to go around to every single company in Thailand on a consistent basis and monitor bribery and corruption. There are too many personal interactions, it wouldn't be possible. But if you push that compliance effort and privatize it into the organization and require that they disclose what their procedures are, and if they don't, and there's a problem, they're guilty. It's not like they can go to court and say, well, we didn't know. The way the legislation works is if an agent of your company, and it doesn't mean an employee, any kind of agent that you use, in any way, an intermediary, whatever, commits bribery, the company is now guilty of the crime as a company and can be sanctioned as a company. It can have its license withdrawn. It can have to pay penalties, right? It may not be able to trade in certain areas for a certain period of time. There are all kinds of problems the company can face. Now, they're not perfect, right? Because it's hard to hold an organization liable, and so it's not perfect. One thing the UK does that's actually quite beneficial, and they borrowed this from the United States. If the company doesn't have adequate procedures in place or doesn't have a system in place, and an act of bribery occurs, then the company will be automatically liable, but the state has the ability to defer prosecution. So what the government can do is say, you're guilty, we won't prosecute you on this one, as long as you come up with a system to prevent it in the future. So again, the state can force the organization to then put the system in place, and they will review the system, monitor the system, make sure it's adequate for purpose. And if they'll say, if you don't commit the act within 5 years and you put a system in, and we will send a government-sponsored monitor to check up on you every 12 months to make sure the system is actually being put in place. We'll do investigation, et cetera. And then if everything is okay in 5 years, we'll forgive the first act, as long as nothing happens. It's pressure, right. So again, it's more efficient from the state's perspective because they don't have to go company by company and audit every company. They can find a problem, a troubled child, and correct the behavior, or tell the child, tell the company to put a system in place to fix it.
Just wonder what is the model that the UN would use in order to.
Yeah. Well, yeah, I don't want to.
I don't know whether they're going to anti-corruption.
Yeah. Well, I'm not gonna speak for the United Nations. I don't work for them, and I don't feel like going after them. Yeah.
Just a short question.
Yeah.
For unlimited counsel. How this could regulate the offshore companies that are addressed in Ruggie reports, which are more or less related to human rights violations and are PM as the private military security companies, since the Russian private military security companies such as Mora Security Group or ISB and
Or like Blackwater in the U.S., right?
well,
Z,
that's
yeah.
different because they have offshore base.
Okay.
So they're registered in Belize and British Virgin Islands, while American and British private security companies are domestically.
Yeah, right.
So it's easier to regulate them
Right.
than those. Plus, how the name and shame would affect those companies if their business is related to something that is beyond name and shame. And third more things, how the law could regulate the states that didn't ratify the Supreme Court of Justice and would not send their citizens there, even they have offshore-based companies.
Okay. Yeah. I mean, well, there are a couple of. I mean, these are obviously quite big questions, right? I don't know that the current regulatory structuring process would be able to address that directly, adequately. I think the lack of access to the ICC is only in the context of international crimes, right? And there are other tribunals that handle human rights issues, et cetera. But under Pillar 3 of the Ruggie and the United Nations guiding principles, the nation states are supposed to now also find ways to design remedies for access to local forums. So that, unlike the US, where they said, well, look, if the crime is extraterritorial, you can't come to US federal courts, the US federal system will have to change to accommodate those crimes that are committed in other places. So, for example, if Belize is part of this process, they will have as a state a requirement that they allow victims to come into Belize or in other forum, right, to get a remedy of some sort against these actors. So I think in one sense the question is a very good one, in the sense that you have all these overlapping complex perspectives on what's happening and who's going to enforce what. I think as far as trying to fill a gap where companies can get away with basically anything these days, and there's no enforcement mechanism, and there's no forum, that this at least tries to push back on sealing up that gap, which is significant. I don't know, again, that it's adequate at the moment for dealing with the specific kind of situation you're talking about, but it might help. I think a lot of times these companies get away with what they do because nobody knows what they do. So flushing that out into the light would be actually a little bit helpful. But that's just my perspective.
Yeah.
Okay. Question? Okay, great.
Thank you.
Thank you so much.
Thank you very much.
Sure, thanks.